Hi friend, welcome to the Company Law Adjudication and Appeal Series. Today we are discussing daily ROC adjudication order in the matter of the Garage Co. vs. Private Limited for the violation of Section 12, that is non-maintenance of the register office. This case is initiated on the basis of the online complaint received by a party. Let's see the facts of the case. The company name is the Garage Co. vs. Private Limited, having registered office in Gurgaon, Haryana, as per the MCA record, and as per the immediately preceding financial year, the details particulars of the company as per the MCA record. There is a paid up capital as on date. It is the 2 crore 86 lakh 10,970, and turnover is the 42 lakh 40,201 as per the MCA record for the financial year 2018-19, and company is a holding company of the Singapore company. From the facts of the case, this is says that is since the company is the holding company and it should not cover under the definition of the small company for imposing lesser penalty. Let's see the facts of the case. An online complaint was received in this office through serious fraud from a party named KRW Leasing LLP against the aforesaid company, addressing default of non-maintenance of the register office. In the said complaint, the complainant KRW Leasing LLP, this company is a lesser company, informed they are the owner of the entire building consistent of the basement, first, second and third floor are situated at the address where company is maintaining register office as per the record. The said premises was leased to this company Garage Co. Private Limited along with the furnishing fixture, right to use common area, etc. By lease date dated 12th June 2020, which was effective from 1st April 2020 for the period of 14 years and 4 months in consideration of monthly rent. The premise was leased for the purpose of operating business relating to IT and ITES services. That the subject company had failed to make the rent payment and other dues to KRW Leasing LLP since the commencement of the lease deed. Therefore, they had terminated lease deed in month of March 2021. After so many notices, requests and negotiation, the subject company Garage Co. Private Limited had handed over the possession of the property on 31st August 2021. It was further informed that that presently the company is operating and running its business from new premises, Garage Society, 11th Tower B, Imam Digital Greens Sector 61, Gurugram, Haryana, from another business premises where no record shown. That is the register office of the company. The complainant further complained that even despite handing over the premises in question by the company and operating as a business from new premises, the company in question has not filed any INC 22 form before ROC office, that is shifting and change of the register office in compliance of section 12 subsection 4 of the Companies Act. The said complaint was taken up by this office online with the company by issuing online notice, in response to which company replied letter dated 25th October 2021 to this office, admitting the fact that they had taken premises situated at plot number 270 phase 2 Udyog Vihar, Gurgaon, Haryana from complainant and had handed over the possession of the same to them on 31st August 2021. Company further informed that they are still in the process of shifting a register office and will inform authority accordingly. Further, a writ petition was also filed by the complainant in this matter before Honorable High Court praying for initiation of appropriate action against the company for default in complying with the provision of Companies Act regarding change of register office. The said petition has been disposed of by order dated 13th April 2022 in favor of the petitioner complainant with direction to this office to initiate appropriate action as warranted in the matter as per the law. In terms of the record available on the MCA portal, companies are still showing a register office at this address, despite the fact the company had already handed over the possession of the site premises long back as admitted by itself, dated 25th October 2021. Thus, in effect of the company has failed to maintain its register office in terms of section 12 of the Companies Act. So-called notice was issued to the company and officer in default on 29th April 2022, fixing date of the hearing 11th May 2022, and was sent to the register post as well as email to the company and officer in default for foreign national through email, but as per the postal tracking record, the so-called notice was not delivered to the company, which is understandable as to the company is not maintaining its register office on the address intimated to this office. Further, no person from the company side attended on a hearing on 11th May 2022, nor did anyone furnish any written reply. As per the relevant provision of the Companies Act, as per section 12, subsection 1, a company shall and on from 15 days of the incorporation and at all time thereafter have a register office capable of receiving and acknowledging all communication and notice as may be addressed to it. And as per subsection 4, if any change in the situation of the register office after date of incorporation, company shall be given to the registrar within 15 days of its change of register office, who shall record the same. And as per section 12, subsection 8, if any default is made in the complying with the requirement of this section, the company and every officer in default shall be liable to a penalty of 1,000 rupee for every day during which the default continue, but not exceeding 1 lakh rupees. In adjudication penalty, in the present case, it is evident that the company has not been maintaining its register office in terms of section 12 of the Companies Act. The date of non-maintenance of register office is reckoned from the 1st September 2021, that is the next date after handling over possession of premises to till date, that is the default is for 254 days. No one on the behalf of the company and officer in default has come forward to defend their case despite the facts and notices were sent to them. In terms of the para 2 of the order of the company does not certify the requirement of a small company under section 2 clause 85 of the Companies Act. Therefore, amount of the penalty as provided under subsection 8 of section 12 is leviable on the company and on 2 foreign directors. And there is the maximum penalty imposed on the company, that is on the company 1 lakh and on 2 director 1 lakh each. This is a total 3 lakh penalty imposed on the company and directors. The company and its director are directed by this education order to rectify the default immediately on the date of the receipt of the copy of the order and file e-form to record, register the details of new register office of the company. The notices shall pay the said amount of the penalty through online mode by using MC website and intimate this office with the proof of penalty paid. In case of above mentioned office in default, penalty is required to pay from their own fund. If prefer appeal against this order, then file appeal within the 60 days from the date of the receipt of this order to RD along with the grounds of the appeal and accompanied by certified copy of this order. Thank you so much for watching this order.